All right, so let's get into the majority opinion here, and then I want to talk about the dissenting opinion. So I'm quoting from the majority opinion, which again, the question that was well, let's say rather than the question.
Actually, time out for 1 second.
Sure.
If you want to read along with the majority opinion, go to find me on Twitter at Andrew_Langer. I have tweeted out the opinion on this. You can go find it there. Firearmspolicy.org also has it in PDF on their website right now.
Absolutely. Yeah. All right. So
sorry.
The majority says the plaintiffs contend that the good cause requirement for concealed carry, as interpreted in the policies of the sheriffs of San Diego and Yolo counties, violates the Second Amendment. They say the plaintiffs' arguments in the two cases differ in some particulars, but they essentially proceed as follows. First, they contend that the Second Amendment guarantees at least some ability of a member of the general public to carry firearms in public. Second, they contend that California's restrictions on concealed and open carry of firearms taken together violate the Second Amendment. Third, they contend that there would be sufficient opportunity for public carry of firearms to satisfy the Second Amendment if the good cause requirement for concealed carry, as interpreted by the sheriffs of San Diego and Yolo counties, were eliminated. Therefore, the court says, they contend the county's good cause requirements for concealed carry violate the Second Amendment. The court says, while plaintiffs base their argument on the entirety of California's statutory scheme, they allege only that they have sought permits to carry concealed weapons, and they seek relief only against the policies requiring good cause for such permits. Notably, the court writes, plaintiffs do not contend that there is a freestanding Second Amendment right to carry concealed firearms. No, they don't. They contend that there is a freestanding Second Amendment right to carry firearms.
Yes. And more to the point, they're challenging this because they know historically courts have looked down on a subjective measurement by which people can go about exercising their rights.
Right. Now, in California,
and you want to have a narrowly focused case, because that way, and we could talk about this with Kurt, that way you have a greater expectation that the court is going to rule on the merits of your specific issue.
Yes.
Yes.
So the court goes on to say, we don't reach the question whether the Second Amendment protects some ability to carry firearms in public, such as open carry. The Ninth Circuit in the Peruta decision says we're not even going there. We're not even answering that question. So we will leave this unanswered as to whether or not the right to keep and bear arms means that you have the right to bear arms.
Yes.
We're not going to address that. The court says that question was left open by the Supreme Court in Heller, and we have no need to answer it here. Because the plaintiffs challenge only policies governing concealed carry, we reach only the question whether the Second Amendment protects in any degree the ability to carry concealed firearms in public. But that is not actually what the plaintiffs were challenging.
No.
The plaintiff's argument was, again, look, because of the way the laws are written in California,
yes,
we can't openly carry for self-defense.
Yes.
We can't even openly carry an unloaded firearm for self-defense because that has been declared illegal. So the only thing that we can do would be to get a concealed carry license.
Yes.
And we can't do that because self-defense isn't seen as a valid reason to carry a concealed firearm in San Diego and Yolo counties. And the Ninth Circuit blows right by this. Says we're not, no, look, they were only challenging the concealed carry policy, so we don't have to talk about whether or not the policies as they fit into the rest of California law results in an infringement of the right to keep and bear arms.
Yes.
That's in essence what the Ninth Circuit majority opinion says. Now, the dissenting opinion, I want to skip down to the dissent if I can for just a second here, because the dissenting opinion, and again, this was a 7-4 decision. The dissent by Judge Callahan, joined by Judge Silverman, except for Section 4 of the dissent, and Judge B and Judge N.R. Smith. This is all their dissent. And this is how it starts. The Second Amendment is not a second-class constitutional guarantee. In the watershed case, District of Columbia versus Heller, the Supreme Court held that the Second Amendment codified an existing individual right to keep and bear arms for self-defense. 2 years later, the court reaffirmed Heller and McDonald and held that the individual right to keep and bear arms for self-defense under the Second Amendment was fundamental and applied to the states. Although these opinions specifically address firearms in the home, any fair reading of Heller and McDonald compels the conclusion that the right to keep and bear arms extends beyond one's front door. Like the rest of the Bill of Rights, the dissent says, this right is indisputably constitutional in stature and part of this country's bedrock. And then the court, the dissent addresses the majority argument here. They say the majority sets up and knocks down an elaborate straw man argument by answering only a narrow question, whether the Second Amendment protects a right to carry concealed firearms in public. The dissent says this approach is contrary to Heller and contrary to the prescribed method for evaluating and protecting broad constitutional guarantees. Indeed, the dissent says the majority's lengthy historical analysis fails to appreciate that many of its cited cases either presumed a right to openly carry a firearm in public or relied on a pre-Heller interpretation of the Second Amendment. Because the majority eviscerates the Second Amendment right of individuals to keep and bear arms as defined by Heller and reaffirmed in McDonald, I respectfully dissent. So, you know, you've got a, and I noted this as well. Before the show started, as I was just glancing through the majority opinion, a lot of the cases that the majority cites in support of saying, well, look, there's no right to carry a concealed handgun. These cases talk about, well, you can carry openly.
Yes, absolutely.
And so, therefore, it's okay to regulate the right to carry, to regulate concealed carry because we're not going after your right to carry.
Yes.
We're saying you can still carry openly. The Ninth Circuit majority opinion blows right by those facts in the cases that they cite.
Let me point out two things. That in the dissenting opinion, there's language that is used, which is very similar to language the Supreme Court used in the 80s and 90s in talking about property rights cases. That very famous Supreme Court case in which the High Court said that property rights are not to be granted the status of distant relation when in the universe of individual rights that are out there. Second, you know, you and I have talked about this extensively about the end run around the Second Amendment. That this is exactly how the Second Amendment, anti-individual right to keep and bear arms crowd wants to go about doing this, right? I mean, as we were just talking about with Jim, there are folks who want to see the Second Amendment entirely repealed, no individual right to own firearms, keep, whatever.
Right.
But what they can do without achieving that, without going after that, is by making the Second Amendment a poor relation to the other amendments, and then chipping away at it by chipping away at various aspects of it, right? Rights come in a bundle. We should definitely talk about this with Schlichter. Rights come in a bundle. They call it a bundle of sticks, right? A bundle of sticks, if you put it together, you know, you can't break it, but you can break each stick individually. And eventually, if you break enough sticks, the entire bundle isn't strong at all. It's very weak. It's hollow. In the end, the anti-Second Amendment crowd gets what they want, which is the evisceration of the Second Amendment. Whether they do it by chipping away at, concealed carry or open carry, whether they do it by taxing firearms and ammunition, whether they do it by going after, via Operation Choke Point, the manufacturers of guns and ammunition, et cetera. It's all a way of achieving the same goal, the evisceration of the Second Amendment.
I think you're absolutely right about that. And we've seen this in terms of how Washington, D.C., for example, responded to the Heller decision, how Chicago responded to the McDonald decision. They didn't say, oh, God, that's horrible. We've been violating people's constitutional rights. We need to, we need to address this, right? What they said was, well, we don't agree with this, so we're going to tweak our laws a little bit, but we're still going to make it as hard as possible for people to exercise that right.
Yes. And see, this is where the federal laws that are on the books protecting due process rights come in, right? Because it's all bound up together. All of these things are bound up, again, in the general bundle of rights. So you have a right to both substantive and procedural due process, i.e. you get a fair shake. When you have to find a way to exercise those rights before a government body, they're supposed to give you a fair shake. And in instances in which they enact hollow regulations that are merely designed to make it impossible for you to exercise those rights, at least to me, that is a violation of both your substantive and procedural due process rights on their face.
I'm talking again with Andrew Langer from the Institute for Liberty, and we are going to be talking more about the Peruta decision handed down by the Ninth Circuit. This is the en banc decision. The Ninth Circuit saying today that the Second Amendment has nothing to do with carrying a concealed firearm for self-defense. Now, again, they say we're not even going to get to the question of whether or not the Second Amendment is about carrying a firearm. We're just addressing this one narrow question about whether or not the good cause requirement there in San Diego County And it's amazing to see.
And you only live once, county.
You're right, exactly. YOLO. It's amazing to see, by the way, the Ninth Circuit act with such restraint here, right? Like, well, we don't want to get too broad. We don't want to answer too broad.
I know we're close to a break. I will say this much. You know, it underscores for me the lower court decision of which this is overturning, written by Judge Kaczynski, underscores to me why at least I would like to see somebody say that they want to nominate Judge Kaczynski to the High Court. He's a brilliant jurist, a brilliant lawyer. He's a fun guy to sort of get to know. He spoke at the Competitive Enterprise Institute dinner a few years ago. And, you know, this is a guy who really ought to go places.
Yeah, listen, the opinion, I don't know a whole lot about Justice Kaczynski. I understand that he's fairly libertarian.
Very libertarian.
But the original
and a heck of a
opinion.
Snowboarder.
Really?
Yeah.
Oh, even better. The original opinion in the Ninth Circuit, which he authored the majority there, it was well thought out.
Yeah.
It explained things very, very well and went through the history. This is, and again, it actually looked at the history not to try to, not so that he could say, okay, let me cherry pick some cases that make my point. But it was really more of, let's go back and let's look through history.
That's what he does.
Right. And unfortunately, with this majority opinion that we saw today, the Ninth Circuit says, okay, let's take a look at the history here, right? But because they have already decided, well, we're not going to talk about the entirety of California's gun laws. We're not going to talk about the fact that under the laws of California, people cannot carry a firearm for self-defense. We're only going to talk about concealed carry. Again, they cite cases from the 1800s that said, you know, listen, no person can carry concealed or on their person a dirk, a dagger, a pistol. But those same decisions said this in no way regulates or bans the open carrying of firearms. You know, and we get into this in the dissent today, where the justices point out you can't find the cases. You can go back from 1789 to now, and you can't find the cases that say, no, there is no right to carry a firearm anywhere, anytime. And in fact, when you look at the Heller McDonald cases, you actually do find justices saying the opposite.
But this is, of course, how the anti-2A crowd wants to whitewash American history on this point. It's why they've expended so much time and effort to go after John Lott and his research on the traditional personal firearm ownership in America. That they want to establish this history that, no, Americans never carried their own firearms. It was never allowed, which is just a complete, well, not ignorance because it's willful, but a complete whitewashing of history.
I want to talk more about the dissent in the Peruta case because there's something really, really interesting here. So the majority opinion says, well, we're not going to talk about whether or not this policy in California that says you have to have good cause to get a concealed carry license, whether or not that combined with the prohibition on openly carrying a firearm for self-defense, whether or not that gets to an infringement, because they say that that's not really the question here, and they say the court has left open the question of whether or not there is a right to carry. That's what the majority opinion says. Here's what the dissenting opinion says, talking about the Heller case. The dissent says, importantly, while the Supreme Court enumerated 4 presumptively lawful long-standing prohibitions, and these were the 4 that they talked about. The gun control advocates love to cite this portion of the Heller case. They said that nothing, in our opinion, should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places, such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. Now, the dissent in Peruta today says the court identified concealed weapons prohibitions as an example of regulating the manner in which individuals can exercise their right to keep and carry a firearm for self-defense. And this is really important. The dissent says the Supreme Court further noted in Heller that a prohibition on carrying concealed handguns in conjunction with a prohibition on the open carry of handguns, in other words, what exists for the vast majority of California residents right now, quote, would destroy the right to bear and carry arms. Quoting again from the Heller decision, the Supreme Court Few laws in the history of our nation have come close to the severe restriction of the district's handgun ban, and some of those few have been struck down. In Nunn versus State, the Georgia Supreme Court struck down a prohibition on carrying pistols openly, even though it upheld a prohibition on carrying concealed weapons. In Andrews versus State, the Tennessee Supreme Court likewise held that a statute that forbade openly carrying a pistol publicly or privately without regard to time or place or circumstances violated the state constitutional provision, which the court equated with the Second Amendment. That was so even though the statute did not restrict the carrying of long guns. See also State versus Reed, quote, a statute which under the pretense of regulating amounts to a destruction of the right or which requires arms to be so borne as to render them wholly useless for the purpose of defense would be clearly unconstitutional. Again, that was from the Supreme Court Heller case. The Ninth Circuit majority opinion today says the Supreme Court didn't talk about the carrying of firearms in Heller. So we leave that question still open.
Because they know in the end that when this case gets appealed, if it goes up to the high court as is, or if someone on the left becomes president and a left-leaning justice gets nominated, then well, if it stands the way it is, and unless it's overturned, it stays the way it is. It is a long way of sort of going about doing it. Tie goes to the runner, as it were, unless a conservative gets appointed to the high court before this case gets appealed. And that's what they're banking on. And that's why I say that the decision is so incredibly politically cynical, right? To me, you cannot, judges are supposed to be impartial, but I think you cannot be a judge dealing with an issue like this in America and write an opinion like this without it being seen as entirely and incredibly cynical way of looking at things. And to me, that's sort of an abuse of the process. I mean, after all, we've been waiting, almost a year for this decision to come out. For it to come out now, within days after Hillary Clinton is the presumptive Democratic nominee, not that they were paying attention to what the platform committee was doing,
right,
but nevertheless, the timing on this.
We also have the D.C. Circuit,
yes,
which is dealing with concealed carry issues as well. And, again, nobody knows what goes on behind the closed doors. You rarely see leaks from the judiciary, right? So I don't know about the timing of this, but I do know that a lot of folks expected a decision a little bit earlier. I mean, next week would be a year. June 16th, 2015 was when oral arguments were held in this case en banc.
Wow.
And I'll be very curious, we'll ask Steve Hallberg about this, but I'll be very curious if there was any indication during the oral arguments en banc as to whether or not the justices were going to simply throw out or ignore the argument that looking at the policies there in San Diego and Yolo counties in conjunction with the state law banning the open carry of even an unloaded firearm, if there was any hint that that was how the court was going to try to dodge this issue.
And let me just sort of add something to my proclamation of cynicism, political cynicism. The Ninth Circuit is the most overturned circuit in America.
Yes.
The Ninth Circuit judges are well aware of this fact. And for them to author a decision like this and send it up, again, knowing full well that if it's taken up by the court now, in the way the court is made up now, then it stays. And that, to me, is just dastardly. And yet another reason why the Supreme Court is such a huge issue this election cycle.
Absolutely. Yeah. I think the Supreme Court is probably the biggest issue this year because we're talking about, the possibility, the distinct possibility. We know that there's going to be someone replacing Antonin Scalia on the bench.
Yes.
Who's that going to be?
Mm-hmm.
We know that there's also likely to be more appointments during the next 4 years, certainly the next 8. And then you're talking about, again, a body that is shaping the direction of this country, not just for the next 4 or 8 years, but for the next 48 years, right?
It makes me think about something that Jim Garrity was talking about, which was how decisions can change things on a dime. And I think back to a series of Supreme Court cases when the court really shifted back towards the right in the mid-90s. And you had the Lopez decision on the Gun-Free School Zones Act, and you had the Prince decision in which local sheriffs were being made essentially as minions of the federal government. And the high court finally started to put a stop to those things. This is, and now that's almost a generation ago. I think, unfortunately, the pendulum has swung back the other way and is starting to swing back the other other way. But at that point in time, Cam, when you're talking about 1995, 1996, where you'd had essentially 50 plus years of an unceasing expansion of federal power with the approval of the Supreme Court. I mean, you think about the damage that was done to American society over that time, how government was allowed to expand in every facet of American life, and we've only in the last 20 years or so been able to chip away at that damage. We're really looking at, this is why the Supreme Court is such a massive issue, because an individual decision that can be made, think about it. You think about the Heller decision and how monumental that was, given however many years of the law existing in the District of Columbia. When you want to turn back something damaging that the high court does, you have to be thinking a dozen years in advance. You have to find the right plaintiff, the right case or controversy. You have to argue it the right way, and it becomes such a gamble down the road. We really can't take that chance.
No, I don't think we can. All right, we've got about 60 seconds left here in hour one. Andrew's going to be with us throughout hour two. Steve Hallbrook, Antonia Okafor coming up. We're going to talk more about the Ninth Circuit decision here in Peruta. Remember, too, that the Supreme Court did recently talk about the Second Amendment in a case. It didn't hear this case. It sent it back down to the district court level. But it was Catano versus Massachusetts. And this was a case dealing with whether or not the possession of a stun gun was allowed under the Second Amendment, because Massachusetts said, no, it's not. Said that this is not protected because the stun guns were not in common use at the time of the Second Amendment's enactment. Said that the stun guns are, quote, dangerous per se at common law and unusual, and said that this was, the prohibition of carrying dangerous and unusual weapons are just fine. The Supreme Court said, no, that's not what we said in Heller. And there's some other reminders in the Catano decision that are worth talking about.
It's funny, Cam, a couple of Christmases ago, John Pop got me a dinger that we use on my show all the time. And I keep reaching over wanting to ding the dinger when you say stuff like that, and I just don't have it with me. It's funny because this is exactly what the folks who are proffering this lunacy don't get, is that you are making people less safe when you do this. And it's funny because, I was telling you before we had Antonin on, I have friends who teach down in Texas who simply do not get this. One professor at an unnamed Texas university in particular, who was on social media saying that she, thought she was crazy for, people think she's crazy for being opposed to concealed carry on campus, without recognizing the point that it's supposed to make you safer, less of a target, by making the spaces in which people feel free to operate severely limited.
Yeah, and I'm looking here at the New York Times write-up of this decision. Awful. Absolutely awful. And I want to call them out by name. Adam Nagurney, Eric Ekholm. Awful coverage. Here's what they say.
Nagurney was called a particular name by Vice President
Dick Cheney.
Dick Cheney, yes.
Yeah, I know. So here's what they write. The 7-4 ruling by the U.S. Court of Appeals for the Ninth Circuit in San Francisco overturned a decision by a 3-judge panel of the same court was a setback for gun advocates. The California law requires applicants to demonstrate good cause for carrying a weapon, like working in a job with a security threat. A restriction sharply attacked by gun advocates is violating the Second Amendment right to bear arms. No, that's wrong. The California law requires applicants to demonstrate good cause for carrying a concealed firearm. There's no way to legally, openly carry a firearm, as we've pointed out. And the New York Times story completely avoids any mention of this entire argument.
And also fails to recognize that it's not just a standard that you feel that you're in a job that's unsecure. You have to demonstrate that you have been threatened. It goes well beyond that. I mean, that's the insanity of this, of the San Diego rules. That's why subjectivity is supposed to be reined in.
Anyway. Absolutely. More from this. The decision by the 3-judge panel of the Ninth Circuit had thrown out the requirement that a gun owner demonstrate, quote, good cause for getting a weapon. Again, no, this is not about getting a weapon. This is not about getting a firearm. This is about getting a concealed carry license to carry that firearm. Within days of that decision in 2014, the New York Times writes, counties across the state which administer the permits reported getting a flood of applicants seeking concealed weapons permits. Although the decision was stayed pending appeal, some county sheriffs began issuing permits. The status of those permits not immediately clear. in a dissent to Thursday's ruling by the full court, Judge Consuelo Maria Callahan said that the Second Amendment protection to gun owners that applied in the privacy of one's home, upheld in a 2008 Supreme Court decision involving a law in Washington, D.C. A law. That's as specific as they're going to get. Quote, extends beyond one's front door. Like the rest of the Bill of Rights, this right is indisputably constitutional in stature and part of this country's bedrock. That's the entirety of the quotes from the dissent in the New York Times story. That's it. One line. And it doesn't get to the crux of the argument in the dissent, which is that the majority opinion ignores, again, the totality of the circumstances for folks wanting to carry a firearm for self-defense in California. And it
certainly doesn't talk about the craven cynicism by which I feel that this decision was issued.
It does not.
But I somehow doubt that Nagorny is going to do that, yes.
All right, Andrew, listen, thank you so much, sir, for joining us in studio. It's been a lot of fun.
I'll come back anytime.
All right, let's do it. Andrew Langer with the Institute for Liberty. You can find him online as well at Andrew_Langer on Twitter or instituteforliberty.org.